NZIOB. Following the government's announcement of COVID-19 alert levels, we saw a need for our membership and the wider construction industry to be provided with accurate information or guidance on the critical issues that construction practitioners and companies are facing right now. To identify what those topics were, we surveyed our membership. The top topic that our members sought information on was construction contracts, specifically the status of contracts under COVID-19. To assist us in developing a presentation on this topic, we reached out to MinterEllisonRuddWatts, whom had participated in the NZIOB's recent Building Legends workshops on EoTs. We are very appreciative of MinterEllisonRuddWatts' enthusiasm for being involved in today's webinar, which features two of their construction division partners. Janine Stewart, who has built an increasingly high profile within construction, being a member of the Construction Sector Accord, and also a member of the MB's Building Advisory Panel. Stephen Price, who, along with practicing construction law, regularly lectures at both University of Auckland and at EoT. Titled COVID-19, So Much More Than EoT, today's webinar is designed to address the key contract issues that have arisen since the COVID-19 Level 4 lockdown. The topic has clearly resonated with approximately 400 construction practitioners registered for today's event. With that in mind, the NZIOB and MinterEllisonRuddWatts are looking at running follow-on webinars that address more specific contracts topics. As an attendee of today's webinar, you can play a role in framing up those topics by participating in the post-attendance survey that you'll be sent tomorrow. Before I hand over to Janine and Stephen, I would like to make you aware of our next COVID-19 themed webinar. It is on a topic that also featured strongly in our membership survey, that being well-being. In response, the NZIOB has developed a series of well-being webinars in collaboration with SiteSafe. Over the next month, you will have access to weekly webinars, with the first one occurring next Wednesday at 1 p.m. That webinar features behavioural psychologist Dr. Kyle McWilliams, with the topic being leading your organisation to influence well-being and performance under these tough times. Finally, I would like to acknowledge the support of JIB, the NZIOB's national partner, with whose assistance we have been able to deliver today's events. Enjoy today's webinar. Questions that you ask via the webinar platform will be curated and sent to Janine and Stephen to respond to during the Q&A session. Enjoy the webinar.
Thank you, Malcolm. It's a pleasure to be talking to all of you. It's my first virtual seminar, although I have done many in person. But what I was reflecting on when preparing for this was about 2 months ago, I was asked to speak on a panel on what the construction economy and pipeline looked like for 2020 and beyond. And I sat with a couple of representatives from major listed property trusts and other private developers. And we were asked to be on the panel just before Christmas, and COVID impact didn't really even feature in our outline. About a week before we sat in mid-February, COVID became the big topic, and we were asked to consider what impact it would have on projects. And at that point, we were really looking at supply and materials and how that was going to impact on the industry. The feedback was that vertical industry was going to be more deeply affected than the horizontal infrastructure industry, because horizontal relied on more local supply. And we were seeing at that point a lot of EoT claims from contractors in relation to material supply, moving on to labour issues due to workforce being exposed to people coming in from overseas and having to self-isolate. So we were seeing claims along those lines. But it wasn't until the alert for lockdown that the contractual status of COVID really escalated and required us to closely consider different parts of 3910 largely, but we're lucky to have Stephen with us, who's had to consider both private and public contracts in his role. So we've been seeing some key issues arising in relation to some suspension. I'm sure many of you have dealt with this, whether there's been a change of law, how extensions of time and variation claims would work, how force majeure operates in the New Zealand market, and finally looking closely at mitigation measures, because mitigation applies to construction contracts and construction claims. And I think it's fair to say that we represent clients throughout the hierarchy of construction projects. And we've seen different approaches. Obviously, we've seen contractors who are very keen to make sure that they recover all costs associated with COVID and the lockdown. And we've also seen principals wanting to push those costs the other way. But I think it's fair to say that we've had a number of our clients actually actively seeking to adopt a more collaborative approach and utilise the contract as best they can to do that. But in the end, it is the contract that governs what we do. We are very aware of the MB's directive that's been issued in the last day in relation to how government is treating these issues under 3910 and the NZTA guidelines, and we'll be talking to those as we go through the seminar. So today we're going to cover the issues that I've outlined there. Stephen's going to be working through points 1 to 4, and I'll be raising some issues for his consideration, and then I'll conclude with mitigation measures before our Q&A. So to that end, I'll turn to Stephen.
Thank you for that, Janine. It has been a very interesting time in the last few weeks. Who would believe that just a few weeks ago, if we were being told that we're going to be presenting from our own living room or bedroom or office or wherever it might be over a webinar like this, would be surprised. And I, for one, had a trial midway through, adjourned, part heard because of the lockdown. So it's unusual times. The other thing which is important to understand is that not only are we in unusual times, but we're in uncertain times. I have followed with some interest the announcements that I have seen, newsletters and the like from various law firms, various consultancy practices, various outfits of one sort or another, all expressing the definitive answer, as some of them call it, on these matters. I think it's very important to understand that right now there is no definitive answer, and what that does mean is that it's going to be a matter of working through uncertainty. All we can do is tell you what we think is the most appropriate answer, and people can then take that as guidance from there. But we are going to see many positions being taken over the next few months, I suspect, in trying to resolve these various disputes. Now, first up on the list is suspension. And this is an interesting one to discuss, because the first reactions that we saw when this became an issue with the lockdowns was the contractors obviously pulled out their 3910, jumped straight to clause 6.7, which deals with suspension, and then called upon the engineer to be issuing suspension. And interestingly, a number of engineers did, which I think is good for the contractors, maybe not so good for the principals of the engineers. I have seen some more collaborative and more sensible approaches taken where the engineer and the principal and the contractor have discussed matters and have called it a suspension, but it's suspension by agreement under 6.7.5. The important thing to understand under suspensions is that the use of a suspension, or the need to instruct a suspension by the engineer, is where it is necessary. And obviously no work can be done on sites when you have the lockdown, putting aside essential service sites. But that doesn't mean that the suspension itself is necessary. It's an area which has been interesting to see develop. I've seen contractor-friendly consultancies and contractor-friendly law firms throw up their arms in despair at any suggestion it may not be a suspension, and pointing to comparable, or they say comparable situations like a failure to be able to provide access to the site, things like that. It's totally different from my perspective. It is being used as a way of trying to get to a variation, but I don't think it's a correct interpretation. And the recent government guidelines, interestingly, also say, ultimately, if you've agreed upon a suspension or had one issued, then great. But that's about as far as they go on that. It's of course going to be contract and project specific. 3910 provisions will of course apply in many cases. I'm taking the view that's not the correct approach to the remedies for a contractor. There are other remedies elsewhere, but at the end of the day, if parties are wanting to avoid the uncertainty, then they can, as I have seen some people doing and I'm advising on, go to a suspension by agreement under 6.7.5 and then landing on agreement about what that means from an extension event or a compensation event. So Janine, do you have any comment on that?
We've just been on a call this morning with some Australian lawyers who have been discussing how the issue is being treated over there. And interestingly, my understanding is by and large construction is still going over there, despite the fact that schools are shut and offices are all working from home. And so for them, they're still very much looking at this as a time-only event until there's been some concrete claim made in terms of why it's increased costs. Really just making that as an observation. Have you seen clients make any agreement in terms of how costs will be treated if they do get under 6.7.5?
I haven't seen anyone land on that yet. I've seen both parties attempting their own position. I've seen the principal proposing that it should just be an extension of time-only event upon the making of a suspension. If you have an agreement on suspension under 6.7.5, then unless you agree explicitly to the contrary, it is treated as a variation, so it does bring in the cost elements as well as extensions of time, but obviously the engineers and the principals are pushing for it to be treated as nothing but an extension of time event. And the contractors are generally seeing it as trying to, or at least doing their best, to treat it as a full indemnity against all COVID-19 consequences. I think the answer actually should be somewhere in between. Although I do get there, I personally think it's a different clause under 3910, but certainly those who've been acting a bit more collaboratively are trying to assess the actual impact of the project rather than COVID-19 generally. Obvious points, there will be a disestablishment, re-establishment, costs associated with that, securing the site, that's obviously another cost. There'll be certain time-related costs, even though no one's on the site, which will clearly tie into whether you treat it as a suspension or a provision under elsewhere in the contract. Those sorts of things are perhaps easy ones to work out. Where it gets more difficult is going to be the contractors seeking to recover the costs of their staff sitting back at home unable to work. Yeah,
and I think from what I've seen in some cases, there's been an initial breakdown in relationships when a suspension hasn't been granted because there's been a perception that that's because the contractor doesn't want to pay anything to the contractor associated with the event. But when you sort of delve a bit deeper, it's actually one of the downfalls of the suspension is the termination, is the ability to terminate. And I think once that's dealt with through a discussion or a negotiation, there's some certainty around that. It doesn't, that can resolve some of the issues between the parties. It's not necessarily all about who's bearing the cost.
I think where it does get interesting on a suspension, though, is if it is treated as a suspension from the principal and therefore a variation that flows from that, a case can be made for a contractor to say they want all of the cost implications of the suspension as if it was simply a failure to provide access. And that may well mean that the contractor gets to recover their staff costs and their labour costs, that's the downtime. That's where the suspension provisions as a variation in that regard, if you treat it as being the suspension, that's the variation, not the effect of COVID-19 or the lockdown. It can give different results. So I think it's just important to resolve the cost part. I agree with you that the 3-month termination right is a real one as well, real for both sides, and we've been trying to find in some of our contract party discussions how ways can be formed around that. Obviously, you don't want the project coming to an end in 3 months' time, but you can't have it just box on forever either.
Yep, I think that's fair. Right, I think we can move on. If I can work through how to get the slides moving, but you just carry on with the extension.
Change of law is the other one that has a lot of focus, and this is certainly the one where I think that's most likely to be the correct answer, although there's still a lot of argument over this. So the change of law clause in 3910 is 5.11.10. It does say if you have a change of law that affects the cost of the delivery of the project, and that change of law arises after the tender, then that will be treated as a variation. There are still issues with this. there is still some argument, particularly if you're going to put your principal hat on. There's some argument about whether or not the lockdown has actually come about as a result of a change in law. Contractor-friendly arguments will, of course, point very quickly to the Orders in Council in March, which made COVID-19 a notifiable, quarantinable infectious disease, I think are the phrases. And that certainly paved the way for the government to be able to put in place the lockdown. And contractors to simply point to that. People who are being a bit more principle friendly will point to the fact that the government actually probably had the power even without those orders in council to do what they've done. So the question then is it the change in law that's caused the lockdown, or is the lockdown something which has taken effect and would have taken effect irrespective of the change of law? So there's some issues in there. I think overall it's more likely that the contractor argument is going to win on that one, and certainly that's been the indications from the government paper on where they see it. But even that's not the answer to it, because it still comes down to what costs are recoverable. Again, if I'm putting on my contractor advocate hat, I'd say everything ever, and from a principal perspective, they'll be wanting to narrow it down as tightly as possible. I think it's important to differentiate between the cost of delivering the project and the cost consequence of COVID-19 and the lockdown in general. The principal is getting the project, the principal ought to be paying the price associated with the project, even if that does increase. But the principal can't reasonably be expected, although contractors will, to be indemnifying contractors for the financial loss and other consequences that flow from COVID-19 and the lockdown in general. So I think that's where there's going to be a real challenge to be seen. There's probably not so much argument about whether there's been a change in law, but whether that has A, resulted in the change in costs, and B, if so, what costs. Also important to understand that that's in 3910. I've been doing a lot more work in this area actually on a number of the large projects which are not on 3910, particularly some of the big government projects, and they have different wording. So it's always important to actually look at what the specific wording says. It might be narrower, it might be wider.
Yeah, so when you talk about the paper issued by the government, I think that's the reference to the construction sector accord.
Sorry, that's right, yes.
Yeah, and you're right, they're very much focused on the change in law provision and have essentially given a guideline that there has been a change of law and therefore there is a variation. But and I agree with you. I think it's a hard argument to run that there hasn't been, but there will be some focus now on causation and what costs are actually recoverable. And I think there's been some debate in the technical debate in the market about, well, if we look at how it went through Parliament and where the change of law kicks in and how the lockdown was created, there could be a technical distinction. But equally, there are arguments that the intent of that clause is to really look at what compliance with the law means. So you can see it from both sides, but I think certainly the government has issued the guideline that they'll be looking at it this way.
Where it does get tricky on that is, and I imagine everyone who stops and thinks about this will realise that they'll observe this as well. What you haven't seen in the news at any time is an announcement that says the government has passed a law that enables it to go into lockdown, or the lockdown has been based pursuant to the making of COVID-19 as notifiable disease. It's actually likely a power under the Health Act. They actually haven't given any details, but it's likely a power under the Health Act that has existed since 1970. So the making of COVID-19 as a notifiable disease gives them an easier route, but it's not necessarily the only route. So I imagine that some principals will be taking that issue and saying it hasn't been a change in law. It's been the use of an existing law, and therefore it's not a principal risk. Initial reaction, of course, is always, of course, it's a change in law. There's been a lockdown by the government, but I think it's a bit more subtle than that. But the real issue is going to be, even if there's a change in law, which costs are recoverable, which costs are not.
Mm. And I think that, to the extent to which this becomes a battle will depend on relationships and also the respective parties' balance sheets, because when you're looking in the private sector, private developers and owners, don't necessarily have the same balance sheet to facilitate interpretations that others might. So we'll see how that goes. It will very much depend on project circumstances and contracts, I think.
Well, there's quite different interests in play as well, because the government, of course, has both political and commercial interests, and so I guess this government very clearly is putting in place financial support wherever possible to try to offset the impacts of this. And I imagine that that kind of mindset is also going to carry through to the public projects, assuming, of course, that the contractors act collaboratively rather than in a confrontational way. There are very different interests at stake for private developers, private property owners who don't have the resources that the government will have in relation to that, and are driven at the end of the day also by their own, understandably, own commercial self-interest rather than a notion of the greater good. So I think it's important to understand that there can be idealistic approaches, there can be commercial approaches. The difference in parties' ability to deal with things will drive a lot of it. Desperation will be a big factor in here. There's going to be a lot of businesses, both at the principal side and the contractor side, that will be desperate for a resolution in their favour.
Yes, and I think it's also considering the construction hierarchy. When you think about the fact that at the moment we're looking generically at sort of 3910, and often what I've seen is subcontractor agreements are a lot more onerous against subcontractors than 3910 is against a head contractor upstream, and so we have to recognise that the terms won't actually be the same, and we may well be more reliant on doing the right thing and keeping cash flowing as principles as opposed to contractual terms. But I did hear a comment the other day that essentially, and we may get some feedback on this, but subcontractors from a cash perspective can sometimes be better off than head contractors, because head contractors are often construction management as opposed to holding all the labour and materials, and the subbies have their equipment against their balance sheet. Do you have any comment on that?
Look, that may well be the case in terms of what they're able to handle. It also raises another interesting question, though, which is if, as you are correct in saying, that most of the subcontractor terms are pretty tight in favour of the head contractor, it may well be that the sorts of rights that we're talking about here by a head contractor against the principal are not carried down into a subcontract. And that's got two effects. Obviously, it affects the subcontract, but also affects the head contractor, because if the head contractor isn't liable to pay those increased costs, and that's where most of the increased costs will lie, then that, of course, makes it a far smaller variation claim that can possibly be made upstream as well. So I think it's going to become quite important to understand the full chain of some of these contractual arrangements, even just in dealing with the head contractor and the principal.
Yeah. Right, well, moving on to extensions of time, and I think, as I said in the introduction, this is where we initially saw the claims coming in relation to COVID-19 and delay in materials, and then on to labour. So, Stephen, what has been your experience with...
So you just cut out on that. Can you say that again for me?
So I was just saying that previously we were seeing a lot of claims in relation to time before the lockdown in relation to delay in materials and then labour difficulties. So what has been your experience since the lockdown with delay claims?
Well, I think that's a very fair distinction to draw. I think originally when this became an issue, and I mean this with the utmost of respect to the contractors out there, but they saw it as an excuse to go try and claw back some of the delay that they might be in, to be able to protect themselves from an LD position, or potentially even try and get some time-related costs. So I think there's a real focus on there. People did see it as a timing issue, that the work wasn't changing. It was just going to have largely supply chain issues. The lockdown, of course, totally changes that. The lockdown doesn't just slow down certain parts, it brings everything to a grinding halt. Well, almost everything, obviously. Off-site developed design and the like can still go on. But it does now bring to the fore the direct cost of a project that's not progressing, a project that needs to be subject of disestablishment and re-establishment and securing, a project where you've got no cash flow potentially coming through as a result of the fact no work's being done. So work, of course, will determine the amount of payments under a payment claim. No work being done is going to have obvious cash flow implications, and that's going to carry through in terms of not just on the site, but also off the site for the payment of your day-to-day business operations. Now, of course, that's the same for every business out there. That's not just the construction point. Goes as much for restaurants and cafes as it does for a construction business. But the real focus very much now is no longer a matter of how am I going to offset some liquidated damages. It's very much a how am I going to try to find someone to be able to meet the financial implications of this. And there will be two different mindsets. It's going to be the mindset that says it's not actually related to the project, it's related to the greater business, and all businesses are going to end up suffering for that. And then there'll be the mindset that goes, and I have to say it's very much a contractor sort of thought, I didn't bring this on, I couldn't price for it, and someone else should pay for it. And that's going to be where the real tension is.
Okay. Are there any differences in how you've seen time being treated between 3910 contracts and other contracts you've been dealing with?
Yes, but not so much because of the extension of time point, and we'll come to extension of time in your under 3910 in a minute. So I want to just deal with time generally. Often when people are talking about time, of course, you're not just talking about time for relief of liquidated damages, but you're also talking about time for time-related costs. And so the focus that you will see on each of those particular differences will very much depend upon the terms of the contract. So if you look at 3910, if you're going to go to the obvious clause under 3910 for extensions of time, it's the unforeseeable circumstances, and that clearly gets time in terms of a liquidated damages relief, but it doesn't get anything in relation to time-related costs. That's the easy answer under 3910, probably the least contestable issue in there. But what you do see under other contracts are different allocations on how they allocate responsibility. Some of them provide no relief for a generally unforeseeable circumstance. So you can imagine that has an impact not just on cost, but also on time, and in theory, liquidated damages will become payable at an earlier stage. So there are a number of those sorts of issues that become very dependent upon the terms of the contract. Really what does mean in pretty much every case though is, does it allocate out the risk somehow as a deemed variation matter, like our change of law provisions we were talking about a few minutes ago, or is it purely an extension of time matter, or is it actually purely a contractor risk? Because what people have to remember is the way construction contracts operate is that everything is a contractor risk unless you provide to the contrary. 3910 does a good job of providing many ways to the contrary, including in relation to unforeseen circumstances, but not all contracts do.
Did you want to comment any more on how time is treated under 3910?
Well, time under 3910, if you can't rely on suspension and you can't rely on the change of law, that leaves you just with the extension of time provisions under clause 10. And if you can't get under the other two, you're not dealing with a variation. So it's purely a relief from liquidated damages. And that's going to be something which I think contractors will find unfathomable. Principals will, of course, try to push in that direction, and we are seeing that already. But if you don't get under a deemed variation, then you are just stuck with LD relief, not with any recovery of cost.
Some of the issues that we've had a look at recently involve considering the prevention principle and how that could operate in the current circumstances. And given that COVID-19 is obvious, as you say, it's through no fault of the principal or the contractor, how could you see it applying in projects now in light of COVID?
I've seen already some fairly creative arguments being run, particularly by contractor-friendly advocates, about saying that the inability to access your site due to the lockdown is no different to the inability from a principal to provide the site for access to carry out works. I really struggle with that proposition. I can't see how you can treat them as anything like at all. It is no different to, as I see it, to an inability to access a site because of a volcano or war or something like that. It's certainly not able to be sheeted home in any way to the principle. So that the principal prevention principle is very much about the principal must do everything appropriate to make sure the project can continue. Can't obstruct it in some way, can't fail to do what's necessary to progress it. The lockdown just does not share any link with that. Again, I understand why the contractors want to try to put it in that way, and why they have treated it as directly comparable to just not being able to provide access at all from the principal's part. Bearing in mind the principal, of course, can provide access, it's just that nobody's allowed to leave the house to get to it. So the reason the contractors find it attractive is that if they can treat it equivalent to a breach, then they can, at the very least, recover all of the losses associated with it, but potentially cancel and then sue for loss of profits. So it's very much a financial interest driving it. I struggle with it, but we've seen the arguments already.
Yes, and I suppose it will also, it may become more relevant depending on how principals approach construction sites once they reopen and payments, etc., in terms of how it might operate. But the fact of the COVID-19 itself is not an act of prevention.
That's how I see it. Right now it's very easy because it's nothing that the principals could do in any other way. Getting down to maybe alert level 3 starts raising a whole pile of new issues. Can construction sites open? Does it become too hard that the principal decides not to, but then is that an act of prevention? That's where it will become more interesting. But at the moment, it's very simple. It's not a matter of access, it's a matter of lockdown.
Yeah. Okay. Well, we were talking about force majeure before we move on to mitigation. Force majeure is not expressly covered in 3910. I have seen some commentary that the suspension provisions of 3910 were intended to address events like force majeure. Have you given that any consideration?
I have seen the arguments. It feels a bit to me like wishful thinking as opposed to what the contract actually says. The provisions in relation to suspension do talk about suspension being necessary, but I don't think that's directed at force majeure whatsoever. I just think there's certain matters which come up under frustration, clause 14 I think it is. Otherwise, if it's not dealt with by the contract, you fall back down to common law principles, which again, unfortunately for the contractor is, if you haven't carved it out, it's your responsibility. I should say a lot of other forms of contract do have force majeure provisions, and we're seeing that a lot with some of the big government projects. So very different considerations can apply to different contracts. I think that's an important one to remember. The other thing to remember too is that this is not a situation, at least we hope it's not a situation, where the works cannot be done at any point in time. It's just simply a matter where there is an obstacle at the moment that is preventing it, and we are hoping that we'll come back out of that. So I think some of the approach taken for force majeure is often a matter of, if you have nothing else, give that a shot. I think that the contract actually for 3910 deals with it in other ways, not through suspension. But you have to look at the contracts because the different contracts do have different provisions.
Yes, and it's interesting that 3910 does expressly deal with frustration, but the threshold is so high to establish frustration, and the mere increase in costs, no matter how onerous, is not going to cut it in terms of frustration. The law is really clear on that. And force majeure is seen as a remedy that's available where you've provided for it, that means that there hasn't actually been a frustration of the contract, but there's been something less than that. And I've seen it in the consultant agreements. There are express force majeure provisions. Why do you think they didn't include it in 3910?
I don't know. I wasn't involved in the drafting. I personally question what it would add. I don't think it actually is necessary for this. I do think that you're dealing with 3910 that actually does have a huge amount of carve-outs and allocation of responsibility for unforeseen matters, and the allocation of risk, whether it's time or cost, in different ways. It has to be borne in mind that there are many, many kinds of unforeseen risks. COVID-19 just happens to be one of them. And what 3910 does do to allocate that is, unless it falls within specific boxes, then it's going to be the contractor risk. That's what the contract says. But then there are a large number of boxes throughout 3910, because it is contractor friendly, that sets out where the contractor can recover time only and where the contractor can recover time and cost. So I'd have to say I don't actually see a need for force majeure clause in 3910. I think the risks are dealt with in other provisions of it, one way or another, and if nothing else, in relation to time under the extension of time provisions. But that's, yeah, as far as somebody thinking that clause 6 was intended to cover off force majeure, I can't comment on that. You'd have to ask whoever drafted it, but I suspect that you're not going to find anyone who owns up to thinking that way when they drafted it.
Yes, and I mean, I think another potential point is that 10.3F might capture force majeure because it's not foreseeable.
Well, it would, yes.
And that doesn't, interestingly, that doesn't allow for cost. And from my discussions with some Australian lawyers this morning, that is a position that's been taken in Australia, in some of the states, in some of the contracts. But obviously, if there is a variation because there's been a change of law, as per the Accord's guideline, then they'd be claiming for time under 10.3A, wouldn't they? So,
well, they'd be changing for that. They'd actually be claiming it, that's right, as a variation. I think it's very important to understand, because we're seeing this debate from both sides, where the contractor says, it's not my fault, I should be covered for everything. The principal says, it's not my fault, and it's actually got nothing to do with building the building, unlike, say, a ground condition. So I shouldn't be paying for it. And both those positions are totally justified and totally understandable. Contractor hasn't priced this in, principal also hasn't caused it. And it's not something that's inherently innate to do with the project. So there's always going to be the tension. It has to be remembered that 3910 deals with those tensions across a wide range of matters. And in some cases, it makes it the contractor's problem. In some cases, it makes it the principal's problem. And in some cases, it's a combined allocation of time is granted to the contractor, but the cost risk falls on the contractor. What we're dealing with here, I think, is that in relation to the lockdown and COVID-19, unquestionably, it's covered by, at the very least, the extension of time provisions, so that at the very least, the contractor gets the time risk taken off them, and that is at the principal risk. The real issue comes down to, given the fact it's actually neither the principal nor the contractor's fault, not priced by the contractor, not caused by the principal or inherently part of their project, how does their cost risk be allocated? And that's where you've got to look at those other clauses. And I don't think you need force majeure for that. It's just going to be a matter of, is it a variation? As I said before, more likely yes than no, although probably under change of law, could be argued. And then you get down to how are the costs correctly allocated in relation to that. Because even if you call it a variation, that's not the end of it. The real argument is going to be which costs attach to the variation, which costs do not.
Yeah. Right, well, looking at mitigation now. So we've been talking a lot about what claims are available to contractors as a result of COVID and as a result of the lockdown. And what we also need to remind ourselves of is that the principle of mitigation applies to all claims, whether they're in the construction context or outside of it. And the principle of mitigation essentially provides that a party who has suffered a loss, or in this case, an increase of time and cost, must take reasonable steps to mitigate the loss of that time and the increase in those costs. And normally in construction projects, we see this played out in that if there's been, for example, a site shut down, the contractor must explore whether there are other projects that they can reallocate labour and materials to, for example, so that they're not suffering, we're not having parties sitting idle. If contracts are wrongfully terminated, the principle of mitigation provides that the contractor must consider what projects it can then turn to, or what projects it can pitch for, to reduce its loss of profit suffered well, it's always going to suffer the loss of profit, but to reduce its losses generally in relation to not having any work. But it plays out very differently in these circumstances because no projects apart from essential services are going on. And so we've put some thought into what does mitigation actually look like in these circumstances. And ultimately, it's not, whilst it's up to the party making the claim to mitigate, obviously whatever the principal does has to facilitate this to a degree. So we've spent some time talking about this in both an advisory capacity and with clients generally. Some of our principal clients have been looking at how they might create separable portions once the project kicks off again, so that contractors can get back on site and still maintain health and safety standards by not having all of their workforce on site, but still have work on the go. We've had a look at what programming works can be carried out by the contractor while they're off site, what work is in the pipeline where design and programming can carry on. That's a difficult one because pipeline's a real issue, and I know that that's what the government is working on for projects that are government projects or otherwise benefit the public. We've also had a look at what other steps the contractor could be taking, such as working on its health and safety plan for operating under Code 3 and training its staff on that. The Accord has said that it will be issuing guidelines that will apply under the Health and Safety Act in terms of how health and safety will work on construction sites. Other steps that we've seen in Australia, and particularly in Victoria, where site hours have been extended to allow for the workforce to be staggered on site. But obviously that will come with an additional cost as well. Have you considered this issue, Stephen?
I haven't had to so much, other than in one particular project we're dealing with, which is due to its scale a bit more unusual because there are huge amounts of work that continues to be done on design and not just within New Zealand. So certainly the question is how much focus should be on that and how much focus should be on something else. But I haven't had to deal with the mitigation side of it yet, probably because it's just a bit early.
Yeah, and I think it's very much a proactive step in terms of what contractors can be looking at. But we do know that if there are claims that come out of this, and there are likely to be, even though I do know that some reputable contractors are trying very hard, and principals as well, not to get there, that any decision maker will look at what mitigation steps were taken. So it is important for contractors to turn their mind to this in relation to their claims.
Now, I think most contractors, particularly in the time of uncertainty, will do that. They'll be looking at how they can reduce their costs, whether it's subcontractors that can be laid off or put on hold. If it is a independent contracting workforce, it can just be told not to turn up. Redundancies we've heard in the news, whether there's the ability to use the wage subsidy as a way of offsetting some of those costs, because at the end of the day, you're dealing with construction companies that have very real cash flow issues, and they will be, in their first interest, number one, will be actually mitigating costs for their own survival. Secondary nature of that will be to protect their position in relation to claims as well.
Yes, I think that's fair. Some of the other clauses that I've seen that might come into play are those relating to responsibility for the site during lockdown, the contractor's responsibility as a PCBU to take all health and safety measures that are necessary in relation to the site. And I think once projects get back underway, we are going to see those come into play more. And I think that's probably a session for another day. But have you had any experience with those so far?
Not directly. It's more being a matter of the sorts of comments being made across the boardroom of the various construction businesses and the principals going, how is that actually going to work? How do you in fact use social distancing in a task that actually involves people being close together at times? So it's going to face its challenges. I don't think people have quite got their heads around what they will look like yet. I'm sure some people have, but not the ones I'm dealing with. It's a little bit too far in the future at this point in time. I think it's going to present challenges. There's certainly going to be an efficiency and productivity impact on that, and that will likely end up being wrapped up in claims, I'm sure.
Yeah. Have you heard of, I'm sure you will have, Infrastructure New Zealand's suggestion of a sector-specific alert system, which might allow construction projects to carry on even though schools remain closed and offices remain working from home. Do you see that as a possibility going forward?
Proof in the pudding, really, isn't it? There's still construction work going on for certain projects, so it is possible. Essentially, it's just broadening what one treats as essential services, I guess. So there's no practical issue on it, but I imagine that there's always going to be some people wanting to have their sector brought in sooner rather than later. And no doubt there's going to be some lobbying from all sectors, but construction is a fairly obvious one.
Yes, and I suppose in terms of health and safety and how we can remobilise, the fact that there are essential projects that have continued will at least give us a starting point of what it might look like.
Yes.
Yes. Well, on that note, I think we've covered off the key issues that we've been focusing on over the last 2 weeks, and to be fair, over the last 2 months, if we're talking about time. And we'll now have a look at some of the questions that have been raised through the Q&A session. One of the key ones, Stephen, is what the fish hooks that principals should be aware of under NZS 3910. Are there any others that we haven't talked about?
That's a very wide question. No, I don't think, in relation to this subject, I don't think that there are any other fish hooks jumping out at me. But I do think it's going to be a real question about how one values and allocates the risk and values the cost, and I think that's going to be one which will have a lot of argument, and therefore the principal just needs to make sure that whatever they're doing, particularly if it's going to be treated as a variation, there's variations that might expose them to some kinds of costs and variations that might expose them to greater costs, and it's important to get advice and to understand and think that through before doing what appears to be an obvious thing. And as my example before was, issuing a suspension might give rise to different variation costs being claimable than under the change in law provision. So a principal is going to want to know how to approach that. Engineers advising them will need to know how to approach that. And obviously the contractors will be wanting to get the one that's more favourable to them, which is probably the suspension variation rather than the change in law one. So it's just a matter of actually doing things consciously rather than accidentally.
Yes, and I mean, sort of what I'd have to say is there's been discussions in terms of what will happen on projects at a contractual level, at a moral level, and at a viability level. And in the end, I think viability seems to be the driving factor in terms of the fact that in the end, the project should continue for the benefit of both parties. And whilst the contract must be the starting point, whenever a party is considering their rights, you also have to look at the objective in terms of how you approach it. Another point that I would say for principals is there is a lot of pressure on principals now to do the right thing and keep cash flowing, and it is much more difficult for principals that are facing cash difficulties themselves. And so it will be important for them to really turn to their contract and consider their leverage, whilst also considering how to keep the project and themselves and the contractor going. So,
well, I think that last point in particular in relation to keeping the contract going is very important. I imagine a lot of principals will be turning to the contractor. I imagine a lot of contractors will be as well. But fundamentally, a principal can have all the rights in the world, but if the contractor has gone bust because the contractor simply has run out of money and goes into liquidation, then it's not in the principal's interest. So it actually may well be in the principal's interest to not look to the contract too much and to try and find a way through it and to be able to ensure that the contractor can survive. Similarly, a contractor who pushes the barrier out too far may well find themselves in a situation where it becomes a dispute-oriented approach and they will end up potentially going into liquidation over time instead of having it resolved earlier. So unusual, I know it is, for a lawyer to say don't get too hung up on the contract. This might be one of those times not get too hung up on the contract. I'm aware that with some of the large government projects, there's being far more of a collaborative approach than a technical contractual approach being taken at first instance. Where that will pan out, who knows? I accept the government has the luxury of money always. So it might be a bit different to a private developer, but there's certainly recognition that you do yourself no favours having a bridge half built, a road half built, a building half built.
And I think that's a good point, because when you look at the complexities involved if a contractor goes bust mid-project in terms of getting another contractor on site to do the work in usual circumstances, it's going to be much harder in these times if that happens. So yeah, always looking at the objective is important. Some of the other points that I've seen raised are, if you consider you're entitled to a suspension and the engineer doesn't issue a suspension, what can you do? Essentially, you're stuck, in my view, with the dispute provisions of the contract, which require you under straightforward 3910 to seek a formal engineer's decision under 13.4, and then you're stuck with the arbitration process, which I know isn't very appetizing in these current times. Do you have any comments on that?
I know a lot of people are getting hung up on what can we do if the engineer doesn't issue a suspension, and I think it's a total distraction, because you're not dealing with a situation where the works can't proceed, but the engineer hasn't issued a suspension, so you don't know if you should be turning up to the site tomorrow. Obviously, that's just not a consideration right now. So the non-suspension notice, if you think you should have one, doesn't put you in a case of uncertainty of do I need to turn up to site or not, because that's usually the driver. You don't have that. If the engineer ought to have issued a suspension notice and did not, then that will be dealt with at an arbitration or an adjudication and will be treated ultimately as if it was issued. So rights that will flow out of that will be the same sorts of rights that you would have received if it was an issued suspension notice, and therefore the variation consequences that flow from that, along with any other costs that would likely flow from a breach of contract. So it's received a lot of interest. I actually think it's a bit of a distraction. Obviously, I formed the view, as I've said earlier, I don't actually think that the suspension clause is the right one. But if it is, then a contractor can very easily say, I think you should be issuing me a suspension. If the engineer doesn't, then the contractor can say, I think that you're in the wrong for not doing that, and I'm challenging you on that, and I'm seeking a formal decision and reserving my right, and then go from there. Like I say, the normal impetus is, what do you do in the meantime? Do you turn up to site in the meantime? And that's just not a driver right now.
Yes, and I think from what I've heard in my discussions with adjudicators, they're actually very busy right now and see themselves as being busy. I do, often even pre-COVID, when parties went through an adjudication process, even though there's the option of continuing through an arbitration, and it doesn't actually happen very often because of the time and cost involved. So it'll be interesting what dispute forum we see being utilised in these times, even though I appreciate parties would prefer not to go to their lawyers and use dispute processes at all. We may see some of it happening. Another point that's been raised is under mitigation to allow the projects to continue to work under level 3 and 2, how can contractors recoup costs for example, cleaners and implementing health and safety measures? My initial thoughts are that the contractor as a PCBU is responsible for their own health and safety on site, but if there has been a change in law or regulation, that might be a trigger. What are your views, Stephen?
I think that's exactly right. If the correct approach is a change of law, and I still use that word if because I think it's more likely than not that it's correct, but I can come back to that a bit more if I see some of the questions are still asking about that, then the additional cost of labour, cleaning, signage, supervision, that sort of thing absolutely falls within the increased cost kind of clause 5.11.10 wording. Where I see the more questionable cost is the lost profits, the inactive staff and things like that during the lockdown, because I see that as being a potentially different nature of cost. But if it is a change of law and it has had an impact on cost, which are the sort of things that you're talking about there, very squarely are impacting on the cost of doing the project, then that would be recoverable under that.
Because I suppose, and just looking at some arguments that might be out there, if you look at it technically, and you'd have to really explore what creates the health and safety requirements on site, because under the existing Health and Safety Act, the principle is to basically address any hazards and risks, and it's essentially performance based as opposed to being prescriptive about what must be done. And I think we will have to watch the space in terms of whether the health and safety guidelines that come out have what legal basis they are drawn from, and how that would impact on the project as well.
Yeah, well, let me just clarify my last answer on that in that regard, which is the reason I was talking about being a change of law is if we end up with an alert level 2 or 3 and it says as part of the alert what the government direction is that you mustn't work within a certain distance or something like that, then you can see that being a change in law, and therefore, and there'd be a different position to what took place when the contract was tendered. And so that's where your 5.11.10 rights might kick in. But where I do see it as different, if it's not a change in law, is COVID-19 is not a change in law. The existence of the virus is not a change in law. And if in order to fulfill one's health and safety obligations, the correct thing to do is to have social distancing or other things like that, then that's not a change in law. And so that's where it's important to differentiate between whether something is a change in law under 5.11.10 or whether it is just the virus.
Yes, and I think that's going to have some arguments that go both ways on that, and potentially we might be back in 2 weeks' time with some more clarity on that point. The other question that has been raised is if a smaller contractor is using 3915, for example, where there's no engineer administering the contract, is 3910 applicable in the same way? I don't have 3915 on me, but I mean, I think it largely mimics 3910, but for the engineer, doesn't it?
Yeah. Again, I'm in the same position as you. I don't have 3915 in front of me. I look at it less frequently than I do 3910. So I can't say whether there is a directly equivalent clause 5.11.10. There's absolutely an equivalent 10, clause 10.3. And I expect there will be an equivalent 5.11.10. So I don't see it as being particularly different. The engineer really is it's a gloss on it rather than a true functional difference.
I've just been we are coming close to 2 o'clock now. I've just been glancing through some of the questions, and a lot of them do focus on what kinds of costs are recoverable if you're entitled to a variation, and they range from, what happens if I need to find other labour because one of my guys has the virus and has exposed half my workforce, and now I have to go find some more. Are those costs recoverable, for example?
Okay, let's talk about some of the types of costs. And of course, I can't give a definitive answer on what will be recoverable or not, but let's assume that you've ticked off the 5.11.10 box. Because if you're just talking about extensions of time or other risks like which don't fall within 5.11.10, or maybe under suspension, but if you're doing work, you're not suspended. So that's why I'm using 5.11.10 there. Then realistically, if you don't fit within something like that, then it's a contractor cost. The contractor bears that cost. It's a starting point. But let's assume we get to 5.11.10. I can see there being some very easy ones that shouldn't take a lot of argument about. If you've had to shut down the site for a month and then re-establish the site for a month, that would appear to be increased costs as a result of the lockdown. If the lockdown is due to a change in law, that seems to be an easy type of cost that would be recovered. Similarly, things like if you've got an ongoing contract works insurance, that would be something which would clearly be affected by the change in law and by the lockdown. Where I think it's going to become less clear will be the ones which are attributable not to the change in law, but to the virus. So the example you used before was somebody who had to get extra labour because some of their workforce were sick. that's clearly an additional cost. It's clearly got nothing to do with the change in law. So difficult to see how that would be recoverable in any different way to if you had your foreman have a car crash. Didn't expect to have a car crash, but you're going to have to get some other staff on. So that's one of the easier ones I think will be excluded. Where it gets more difficult will be, what about the people that you're paying at home who are at home for the lockdown as opposed to working at the site? And that will come down to the distinction between, is it a change in the cost of doing the job, or is it a change in the cost of business thanks to a change in law? So I can see there being a lot of grey area in that middle space there. Contractors will say, I didn't price it in, I should recover everything. Principals will say, not my fault, not my responsibility, and it's part of doing business, not part of doing the project. And I suspect, like I said at the start of this, the answer is somewhere in between.
I just want, there might be some instances where you might not be able to claim costs, but you'll be able to claim time in relation to an unforeseeable event though.
Absolutely.
But equally,
well, if we can just use that example there, if you can point to an issue in your supply chain, because that's where it really started off, an issue in the supply chain, you can't get product in from China, and that's going to delay the work by a month, then that's a very clear extension of time type claim without any cost recovery attached to it. So there are instances where, particularly in relation to the virus itself, rather than any law, where that could be an extension matter, not a cost matter.
Well, on that note, I think there are a lot of questions that have come in. Hopefully we've managed to get through some of them and that you've found the session helpful. Thank you for sticking with us. We hope to be speaking with you again, and no doubt we'll be seeing contractual disputes or otherwise just debates, because hopefully they don't get to a dispute point, raise some other interesting 3910 issues. So on that note, we'll close. Any further comments, Stephen?
No, that's all. Thank you all very much for attending.
Thank you.